Do FCRA rules apply to landlord background checks? Imagine trying to find the perfect tenant for your rental property and wondering what rules you need to follow. Well, understanding if the Fair Credit Reporting Act rules apply can save you from trouble later. When landlords want to screen tenants, they often use third-party consumer reporting agencies to gather information like credit scores, rental history, criminal records, and eviction reports. If they do, the Fair Credit Reporting Act, or FCRA, definitely applies. This law is designed to protect consumers and make sure they know when their information is being used. So, what does that mean for landlords? First, they must get written permission from the applicant before requesting a background check. This consent should be part of the rental application process and clearly state what kind of reports will be pulled. Next, landlords are required to disclose to the applicant that a background check will happen and specify what information will be reviewed. This transparency helps tenants understand what to expect. If a landlord denies a rental application based on the report, they must give the applicant an adverse action notice. This notice explains why the application was denied, provides contact details for the reporting agency, and informs the applicant of their rights to see the report and dispute any errors. This step is essential to comply with the law and protect the applicant's rights. The scope of what can be reported is also important. Criminal convictions can be shared regardless of how old they are, but arrest records cannot be reported if they are older than 7 years. Landlords can set their own rules about which criminal records disqualify an applicant, but those rules must be fair and clearly communicated. If a landlord chooses to do their own background checks using public records instead of a consumer reporting agency, the FCRA's adverse action rules do not technically apply. Still, it's good practice to inform applicants why they were denied. Lastly, landlords must also follow any state or local laws that might add extra rules or restrictions on tenant screening. These laws can vary widely and may include limits on what criminal history can be considered or how recent records must be for disqualification. In short, if you're a landlord using third-party services for background checks, the FCRA rules do apply. Following these rules ensures you are fair, transparent, and legal in your tenant screening process. Properly handling background checks helps you make better decisions and keeps your rental business running smoothly.